just to give you a little background on me, I've been practicing law for 16 years here in Dothan, and born and raised here, and very proud to be associated with Aaron Gartlan, and also to work the cases that we've worked with Matt and Co. And what I wanted to give you today is some information, some law, basically, on some potential procedural traps, pitfalls, and some evidentiary hurdles that you might encounter when handling the types of cases that we handle. And I've selected some assorted case studies from cases that we've handled and brought some cases to talk about that illustrate these particular topics. Now, the first area that I wanted to discuss is in handling a wrongful death case, who has the standing or the capacity to bring that action when it's not a work-related, work comp related death? And I know you all know the answer to that. The personal representative of the estate has the capacity to bring a wrongful death lawsuit, and that's by statute. What we've seen is a tendency or a practice of having a court appoint a administrator ad litem. Now, that's very appealing in practice because you avoid a lot of the entanglement with the probate issues by doing that. An administrator ad litem doesn't have to post bond and is not concerned with running the ad, the notice of, to potential creditors, and with making reports to the court and all of that. The administrator ad litem is simply appointed for the purpose of representing the estate in a claim that exists and that needs to be handled. Well, we've seen that in wrongful death cases where the probate court has appointed an administrator ad litem. But I want to address with you whether that's the best practice. And in keeping with the theme of David versus Goliath, I'd like to handle this as staying on firm ground and avoiding an attractive but slippery slope. The case that I want to highlight this with was decided in April of this year, and it's called Golden Gate National Senior Care, LLC, versus Donald Roser as the administrator ad litem of the estate of Laura Roser. Now, the court did not make a finding one way or the other really about the role of the administrator ad litem, but we have Justice Bowling giving a concurring opinion that I think should alert us to the possible future risk of handling these types of cases by appointment of an administrator ad litem. In Justice Bowling's concurring opinion, he writes to discuss what he sees as reasons why the law should not allow administrator ad litems to pursue a wrongful death claim. He says, first of all, the wrongful death statute was enacted by the legislature for a definite legislative purpose, and that is to prevent homicide, to deter wrongful deaths in the state of Alabama. And the personal representative of the estate who pursues that wrongful death claim is acting really not as a representative of the estate in that capacity, but as an agent of legislative appointment for the effectuation of that legislative policy. And he says that right is vested in the personal representative alone, and no one else has the authority to bring the wrongful death suit. He then goes into a discussion of two cases that are central with respect to a discussion of administrator ad litems being allowed to pursue wrongful death cases. And the first case that he discusses is Franks versus Norfolk Southern Railway, a 1996 Alabama Supreme Court case that he says arguably started this practice of allowing administrator ad litems to pursue wrongful death cases, wrongful death claims. And in that case, the decedent's brother was appointed personal representative of her estate, but he didn't really seem to have any interest in pursuing a wrongful death case, which needed to be done. His real interest seemed to be merely collecting reimbursement from the estate for funeral expenses that he had paid out of his pocket. And so Justice Bowling says the proper thing to do would have been for someone who was willing to pursue the wrongful death claim to have him removed as personal representative and get them appointed so they could then go pursue the wrongful death claim. But that wasn't done, and you had the defendant who initially challenged the appointment of the, let's see, we had the brother finally coming forward and being appointed as the administrator ad litem. And it was done without notice to the personal representative, not the brother, but another individual, I'm sorry. And it was done without notice to the brother. The brother didn't have a chance to challenge that appointment by the probate court, didn't have a chance to appeal the decision to appoint this other person as the administrator ad litem. And so the administrator ad litem goes forward, files the lawsuit, the wrongful death case, after the statute of limitations had expired. And so the defendant initially challenged the appointment of the administrator ad litem's capacity to bring the wrongful death suit, but then abandoned that and tried to raise it on appeal, but it was not preserved for appeal. And so it was allowed to stand, the capacity to bring the lawsuit as an administrator ad litem. Well, then he turned to Affinity Hospital, LLC versus Wilford. And in that case, you had someone who died in a hospital after treatment. Then an administrator ad litem, the county administrator, was appointed administrator ad litem to get medical records, subpoena medical records, and investigate whether a wrongful death lawsuit should be pursued. And then, after getting the medical records, went on and filed the wrongful death lawsuit. The hospital did challenge the capacity of the administrator to bring the lawsuit as an administrator ad litem. And on appeal, you know, you've seen those appeals where the party failed to cite any legal authority, and so they found no legal authority that said that you can't bring the lawsuit in that capacity, and so it was allowed to stand. But Justice Bowling is not happy with that outcome, and he has done in this concurring opinion what I think is laying the groundwork for a possible challenge in the future that might be successful. And he's gone into the history of personal representatives, the Wrongful Death Act, the Wrongful Death Statute, and again talks about the purpose of the Wrongful Death Act being to prevent homicides, and that only the personal representative is granted the authority to bring the wrongful death lawsuit by statute. Administrator ad litems were never known historically to be personal representatives, he points out. And then he further makes the point that the benefits, the proceeds of a wrongful death lawsuit are not property of the estate. The proceeds of a wrongful death lawsuit pass outside of the estate and go directly to the heirs. And so the purpose of the administrator, personal representative, in pursuing that wrongful death lawsuit is simply to collect that money for the benefit of the heirs to whom it belongs. And he says the statute that allows an administrator ad litem to be appointed defines the role of the administrator ad litem and limits it to situations where there's a proceeding in a court in which the estate of a deceased person must be represented. So he says, first of all, the statute authorizing an administrator ad litem says there has to already be an existing case going on. But the practice is to allow administrator ad litems to initiate lawsuits. It's contrary to the administrator ad litem statute. And where the estate of a deceased person must be represented, he says the estate is not concerned with the wrongful death lawsuit or the proceeds. And so the role of the administrator ad litem is not the suitable office. Yes, sir. Is your question?
I'm the real party in interest. You're out of here.
That's right. If there is an administrator ad litem, the point that I wanted to make in recapping this case is that that's the solid ground to go under. And you know, we've got a conservative Supreme Court, a conservative appellate court, and you don't want to be, I don't think, handling the case on slippery slope, and then this goes up on appeal, and now Justice Boland has laid the groundwork for the defendant to cut your client's capacity out from under you on appeal. So the better practice...
Then I'm a personal representative. Then I move to have the ad litem administrator removed and myself substituted as a real party in interest.
That's right.
And then the legal issue is preserved, and if the court says denies it, then you're ready to take it up to Montgomery.
That's right. Now, so my argument is that from the beginning, if you're representing the plaintiff in a wrongful death case, go ahead and have them appointed in probate court as the personal representative, not as the administrator ad litem, and you're on firm ground, because it's clear that that won't be overturned on appeal, your client's capacity. It's going to be more involved. You're going to have to get involved in the minutia of administering the estate, but if you can get an associate to help with that, or if you want to hire outside counsel to handle those matters, you'll be on more solid ground by avoiding the administrator ad litem route. Now, the next issue has to do with a wrongful death action in a work comp type situation. You have someone who's been killed in a work-related accident, and you're looking at bringing a third-party action against not the employer, but a third party who is responsible for the decedent's death. Who is the proper party in that instance? Who has the standing to bring that action? Well, here's where you have to be careful. The statute does not give that right to the personal representative if there are dependents. Okay? And Section 25-5-11 of the Code of Alabama states that if the injury or death for which compensation is payable was caused under circumstances also creating a legal liability for damages on the part of any party other than the employer, then the employee or his or her dependents in the case of death may proceed against the employer to recover compensation under this chapter, or may agree with the employer upon the compensation payable under this chapter, and at the same time may bring an action against the other party to recover damages for the injury or death. All right, and the case that illustrates that is really a rather curious case, but it discusses the role of the dependent to bring the action rather than the personal representative, and that's Valley Forge Insurance Company versus Alexander. And on the handout I've given you, I've left some room for you to make notes if you want to make a few notes about this, but if y'all want any cases or anything, please feel free to contact me and I'll get you copies of case law. But in Valley Forge, you had a man who was working on some scaffolding on a construction job, and he fell and killed himself. And so Linda Alexander brought an action. The man's name was Frank Alexander. She brought an action individually and as administratrix of his estate against Construction One, who was the general contractor on the job. And there were other defendants as well, but the central point of the case centers around the action for against Construction One. Well, they reached a settlement and they paid her $537,000. Then there was evidence presented. She brought the claim claiming that she had been his wife and that there was a daughter that they had together, Laura, who was born 2 weeks after Frank Alexander's death. And it was alleged that Laura was his only child, Frank's only child. Then you have the guardian ad litem coming in after the settlement and alleging that Linda was never married to Frank. And so he wants to set aside the settlement and have all the money paid to Laura, the little girl. And the court does that and says, well, all right, he found that Linda and Frank had never been married, but Laura was the only child, and so the money goes directly to her. Then the insurance company jumps in and wants to set the whole thing aside and says there was fraud perpetrated on the court because Linda claimed she was his wife and never was, and so this thing was bogus from the very beginning, and the settlement is void. Well, was it or was it not? They were wanting to set aside the award to the child as well. They were saying that the court had no jurisdiction to adjudicate the paternity of this man, with respect to the child. And it's an interesting decision. They ultimately found that the court was able to make the determination that he was the father, even though there was some discussion in there that Linda was married to another man at the time the child was born. And under Alabama law, that means that there's a presumption of paternity in the husband. But the central point in this case was that Linda had also been appointed as the personal representative of his estate, duly appointed by the probate court, and so the settlement was upheld for that reason. Now, she was not his dependent. She could have brought the action, and they point that out in the case, that she would have had the capacity to bring the action as his dependent had they been married. But since they were not married, it survived as a result of her having been appointed. So the appointment of the personal representative is the next in line if you don't have a dependent to bring that wrongful death action. Well, what do you take away from this case? One is you need to identify, when you have a wrongful death case that's work-related, all of the dependents of the decedent. It's very important. If anybody depended on him in whole or in part, because the workers' compensation statute gives partial dependents the right to bring an action as well. And in addition, if you have heirs who may be, that's the key point. Just make sure you identify any and all dependents of the worker, because if you bring that action in the name, by and through the personal representative, and your statute runs, and then it turns out that there was a dependent there who had the authority to bring that act, you're time barred and you're out of court and you're out of luck. All right, my next topic has to do with ancillary probate and competing administrations. Now, I simply wanted to discuss an interesting case that we had in which there was family members from Florida who wanted to come in and try to take the wrongful death lawsuit away from us, where our client had moved from Florida to Alabama, and they were claiming, no, he was still a resident of Florida. And so they were going to try to set up an administration in Florida and then commence a wrongful death lawsuit. But he was living here, okay? Here's a situation, and you'll see these from time to time, where you're representing a family member. They've come to you. You're going to get them appointed as personal representative so you can file that wrongful death lawsuit. But then you've got other family members who want to try to seize control. In this case, we've got competing jurisdictions. And this is something that I think is interesting, because rather than get into the competing, who has the preference in Alabama, I want to discuss a case where two different states are at odds with each other, and who gets the priority in that situation. Okay, you have quick action on our part to get the family member appointed in the probate court of Houston County, Alabama, as personal representative of the decedent's estate. And we get waivers signed by all of his heirs. Now, what's the significance of waivers? It's essentially service on them. Okay, and once you're served, or if you waive service, then you've consented to the action in the court. Okay, so they all signed waivers. We even had one who was in the military, and his mother was holding his power of attorney, and she signed as his power of attorney a waiver for his father's estate. And so then after we begin work on the personal injury case, these other family members in Florida, and some of the heirs defect, and they go down to Florida, but we beat them to the courthouse in Florida too. Why were they going to bring an administration in Florida? Well, one, they were claiming that he was still a resident there, and they said his driver's license, still his Florida driver's license, and he's got a bank account down there and so forth. He owned a piece of land down there with his mom, so he had property there. And you know, if somebody dies and they own property in another state, you've got to open an ancillary administration in that state. Well, we anticipated the coming storm, and we went ahead and we filed in Florida to open an ancillary administration there. Well, they go down to the courthouse in Florida and they file for a competing administration and claim that it shouldn't be ancillary, but it should be an initial probate of his estate there, or administration of his estate, and that he was not a resident of Alabama, and so the judge should ignore what the probate court did here in Alabama. So you've got an interesting scenario there, two states, two competing claims. What do you do? Well, if you remember from constitutional law class, the full faith and credit clause of the Constitution. And it says that states are obligated to give full faith and credit to orders, judgments issued by other states. How does it play in this analysis? Well, the case that we want to examine is a Florida case here, not an Alabama case, because we've got to go to Florida and fight that battle down there and convince the judge down there that the order in Alabama should stand, and that Florida should give preference not only to the appointment in Alabama of our client as administrator, but also give ancillary administration letters in Florida. The case is called Cuevas v. Kelly, and here's what happened in Cuevas. You had a man who had been adjudicated incompetent down in Florida back in 1960. And he lived in a Florida State hospital until 1961, when he was transferred to a VA hospital in Mississippi, in Biloxi. In 1963, he was discharged from that hospital, and then in 1975, he moved into a housing facility operated by Cuevas, the plaintiff or the appellant in this case. And although the case doesn't tell you, I imagine that he probably ran up a bill in that facility that he owed to Cuevas, because when he died in the year 2000, Cuevas filed a petition to probate a will that the decedent had executed. And so Cuevas sent a copy of the papers to the decedent's brother, who is Kelly, the defendant or the respondent, appellee in the case. And Kelly ignored him. He didn't do anything. He didn't take any action in Mississippi to try to move to dispute the papers of the administration or the probate in Mississippi. But instead, he files papers in Florida and asks to have himself named as administrator of his brother's estate. And he says, my brother was a resident of Florida anyway, and furthermore, nobody got permission for him to move to Mississippi because he was under court care here. He was under the administration or the guardianship of a Florida court. Well, meanwhile, in Mississippi, that court goes ahead and admits the will to probate and enters a judgment finding that the decedent was a resident of Mississippi at the time of his death. Then you've got in Florida, the Florida court entering an order finding that the decedent was a resident of Florida. So you've got two different states coming to two different conclusions about this man's residency. And of course, residency is important, you know, when determining where you should file and have your estate administered or your will probated. But the court in Florida reached the decision because they said nobody had approved his move to Mississippi, and he was under a guardianship in Florida. So the Florida court granted summary judgment against Cuevas. Cuevas had come into Florida and moved to set aside the grant of administration in Florida, saying, look, I've got an order from Mississippi that admitted his will to probate. His brother Kelly was served with it and took no action, and you should give full faith and credit to the Mississippi judgment. But the Florida court issues summary judgment. So Cuevas appeals in Florida. And the Florida court on appeal says to determine whether the trial court erred in its ruling on the domicile issue and the validity of the will, we must determine the status of the Mississippi judgment. And they say one who was a party to the proceedings in the first state is bound by the judgment of such court, even upon the question of the testator's domicile. And whether the central issue here is whether the Florida court was required to give full faith and credit to the Mississippi judgment. If that judgment was entitled full faith and credit, then the Florida court lacked jurisdiction to reassess the decedent's domicile. Well, then they cite some of their earlier cases. Courts in every jurisdiction are required to give judgments entered in sister states the full faith and credit of the law. And where a party has had notice and opportunity to be heard, and the foreign court has satisfied Florida's jurisdictional and due process requirements, their orders will be entitled to comity. So, they said, our focus then turns on whether Kelly is bound by the determination of the Mississippi court. They concluded that Kelly, the brother, had notice and an opportunity to be heard in Mississippi, and that the Mississippi court had satisfied Florida's jurisdictional and due process requirements. Kelly was a party to the Mississippi litigation, whether he chose to participate or not. So the Florida judgment, or the Mississippi judgment, was entitled to full faith and credit in Florida. Exactly. And that's what happened in our case. We had the people from Florida coming to Alabama to the probate court and filing an action trying to set aside the grant of letters to our client, the letters of administration. And what you just said dovetails perfectly with the next case that I wanted to discuss from Florida. And here's the important point in follow-up. There's a case called Archbold Health Services, Inc. versus Future Tech Business Services, which was a 1995 case. And in that case, a Georgia corporation, Archbold, filed suit in Georgia against Future Tech Business Systems, a Florida corporation. Florida Tech filed a motion to dismiss the complaint for lack of subject matter jurisdiction, but it never got to the clerk's office. But they sent a copy to the attorney for Archbold. Well, since the clerk's office never got the motion to dismiss nor any other responsive pleadings, then a default judgment hearing gets set. And Archbold's attorney goes to that hearing and shows the judge the copy of the motion to dismiss that Florida Tech's attorney had sent to him. But of course it had never been filed with the court. So the court in Georgia granted a default judgment against the Florida corporation. Well, then you've got Florida, when they try to record it in Florida, filing an objection to it being recorded in Florida, and the Florida trial judge sustained the objection on grounds that the Georgia trial judge didn't consider the jurisdictional issue that the Florida Tech was raising in their motion to dismiss. So you've got to first consider whether or not you even had subject matter jurisdiction because there was not sufficient contacts with Georgia. The Florida Court of Appeal reversed, finding that, first of all, Florida Tech had received fair opportunity to litigate in Georgia, and that the court in Georgia had fairly considered the motion to set aside the default and the motion for reconsideration. But most importantly, the court held that where a defendant challenges the jurisdiction of a court in this other state, and the court overrules the objection and determines that it does have jurisdiction, that decision is res judicata and precludes collateral attack on the judgment, even though the ruling may have been erroneous on the facts or law, and an aggrieved defendant must seek reversal in an appellate court of the state involved, or if he is unsuccessful there, in the Supreme Court of the United States. So, what you had there was they never appealed in Georgia, and what we had here in our case was the family members who came to Alabama and tried to get the probate court here to set aside the award of letters to our client never appealed. And according to Florida, they not only would have had to appeal to the Court of Civil Appeals, they would have had to go all the way to the Supreme Court of the United States before they could relitigate the issue in Florida. So they're barred by res judicata principles. Well, now you may run into a case involving some different state than Florida. I've given you a case from Florida. You might have a Mississippi case or a Georgia case, but it's of interest to me because our case involved Florida, and I wanted to share that with you. What do we take away? Well, first of all, it's important to act early and quickly to get the estate opened and to get a personal representative appointed. And identify and serve all heirs and get waivers from them if possible. If there's somebody who's in the military, try to get their power of attorney, if they've got a power of attorney, to sign a waiver. But even if you can't get them to sign a waiver, you've got them served by sending having the paperwork served on them. And now the clock starts running, and they can be barred if they don't take the correct steps. The next area that I wanted to discuss has to do with federal removal. And you know, when there's a wrongful death case and there's insurance involved, well, first of all, a couple of different things. The plaintiff's lawyer and the defendant's lawyer sometimes are in cahoots against the insurance company if it looks like the insurance company is going to try to get out of covering the event, right? Have y'all seen that happen? And sometimes the insurance company will try to take the position that there's no coverage. I give you an example of one case that we were involved in years ago, but you can think of a lot of different cases. But there was a mobile home that had been moved from the site where it was sold to the place where it was to be set up. So the mobile home movers take it down there and they drop it on the site, and then they leave. Then the setup crew comes in to set it up, and while they're setting it up, it falls and crushes, falls off the blocks and crushes one of the workers. Well, the mobile home mover had insurance, and the question was, from the policy, did it cover that event? And of course, they tried to take the position that it did not cover the event. And if you want to look up the case, it's a federal Middle District court case, Canal Insurance Company versus Cook. And I'll get you the site later, any of y'all that are interested in reading it. But so what happens in a case like that? Well, you've got the plaintiff wanting the defendant to have coverage. I mean, why sue somebody if they're not going to have insurance coverage? And so we're going to try to help the defendant find coverage. But the insurance company is going to bring a declaratory judgment action in most cases to try to get out of having coverage. They're going to provide a defense for the defendant on under a reservation of rights, but then they're going to file this declaratory judgment action. And if the insurance company is a foreign corporation, or if the company that, if the insurance company is a foreign insurance company, not an Alabama resident, they're filing that declaratory judgment action against their insured, not against the defendant, but against their insured, not against the plaintiff, I mean, the defendant. They're filing it against the defendant. Well, you've got several things to consider here. One thing is that your client, the plaintiff, the case law has held, has no standing in that dispute between the defendant and his insurance company. Okay? It's between them, it's a contractual matter, and since it's parties of different states and the amount in controversy exceeds $75,000, they can bring it in federal court. All right? But we can try to help, can't we? We can do research, we can provide assistance to the defendant's lawyer in this particular battle. And one of the things that's important to keep in mind is that federal case law has said that as far as the duty to indemnify is concerned, that issue is not ripe for adjudication until there's a judgment against the defendant. So you can keep that in mind to help, if you're assisting the defendant's attorney fight off this declaratory judgment action, that it's not ripe, and the federal courts will not address the duty to defend until after a judgment has been rendered against their client, against the defendant. Now, the duty to indemnify, though, is ripe, and a court can make a decision about that matter. But what do we want to do? We want to try, if we can, to avoid situations where we get pulled into federal court if we can do something about it, if we don't want to be in federal court. Now, you're going to have to determine in each of your jurisdictions and each of your venues if you might like to be in federal court. You might like your local judge, though, and a lot of times, your local judge is going to be more willing to help a local defendant, especially where issues of coverage and so forth are involved. But something that we can do to try to help in the case to prevent removal is to get the defendant's attorney as early as possible, if he sees that there's going to be a dispute about insurance, to do what? To file his own declaratory judgment petition in state court. And here's the reason why. The Brillhart doctrine. Okay? And the Brillhart case, which I've cited on your page here, Brillhart versus Excess Insurance Company, a 1942 U.S. Supreme Court case, sets forth a doctrine of abstention. Basically, it's where the federal courts really prefer to defer to state courts on issues of this type. And let me the Brillhart doctrine favors remanding federal declaratory judgment actions where there is a parallel action in state court. Where Brillhart does not apply, courts should exercise their discretion to hear declaratory judgments liberally in favor of granting declaratory relief in order to establish the purposes of the Declaratory Judgment Act. All right, and federal courts routinely adjudicate coverage disputes brought under the Declaratory Judgment Act when there is an underlying state court case on the merit which involves different issues and different parties. Okay, so it's a permissive act, though. The Declaratory Judgment Act, the Federal Declaratory Judgment Act, does not give the litigants the right to require the federal court to hear a declaratory judgment action. It gives the court the discretion to hear that action. And they will hear the action if there's not a parallel state court involving identical issues and identical parties. So if you if you can get with the defendant's attorney and get them to go ahead and file that declaratory judgment in state court, then you do have that parallel case in state court, and you've got identical parties involved. So when they try to remove that case to federal court, or they try to file their declaratory judgment action rather in federal court, then the defendant can point out to the court that the parallel proceeding is going on in state court, and have the state court remand the case to your favorable state court judge for a determination. The language is pretty good also. Comity concerns also factor into the equation. Indeed, the Brillhart court made clear that federal courts should defer to prior pending state court actions to avoid gratuitous interference with the orderly and comprehensive disposition of a state court litigation. Federal courts should therefore err on the side of dismissing declaratory judgment actions in favor of pending state court suits involving the same parties and the same issues of state law. So I think that's pretty powerful to avoid having a federal judge make that determination on the duty to defend, at least in the initial instance. Well, so what is our takeaway? If you like your state court judge and you don't want to wind up in federal court, a couple of things. One, and this is something additional that I haven't covered, be careful in your pleadings. If you've got a personal injury plaintiff, not a wrongful death, but someone who's been injured in an accident, don't plead amounts that are in excess of the $75,000 if the defendant is a resident of another state. Be very general in your description of the damages and injuries, and don't invite removal. Secondly, don't be eager to sever claims. If you've got a case involving someone who was injured on the job and you're going to bring a third-party action, don't be too eager to quickly sever the claims for workers' comp and have a workers' comp settlement, because under the removal statute, the federal removal statute, if the case is more than 1 year from the time it was commenced, it can't be removed to federal court. One day before the year. Man, you got to hate that. All right, I'm out of time, but I'm quickly going to mention my last topic, and that is the attorney work product doctrine and investigative reports. The Meadowbrook Insurance Group case was a case where someone had been injured on the job, sued his work comp, his employer and his carrier, alleging that they conspired to try to starve him out, not pay him benefits, and he brought a claim for outrageous conduct, and he sought production of the workers' comp insurance adjuster's claim file up until the date that the lawsuit was filed. But, of course, the insurance company, the defendant, they objected, saying this was our attorney work product. But the state court judge, the trial judge, ordered production. The insurance company appealed, and on appeal, in the Meadowbrook case, they said where the defendant, in this case an insurance company, has a separate and independent contractual duty to investigate a claim, then you got to do more than just say this is work product. You've got to show the reason that the report was prepared and the causal relationship between any impending litigation. And they say, you know, insurance adjusters have a routine duty to prepare investigations, and generally they can be discovered. So here's the takeaway. Each case is going to be different. These types of situations are very fact-driven, but don't accept at face value a claim of work product if you're after an investigation, an audit, some type of report. Do discovery on that. Make them give you a privilege log. The rules of civil procedure say that if you request, if they make a claim of privilege, they've got to make it express, they've got to make an express claim, and if you request, they've got to give you a description of the documents or things that they're refusing to turn over sufficient enough to enable you to challenge the claim. So make them give you that privilege log, conduct discovery directed towards finding out as much as you can about the documents, the report or what have you, and the purpose for which it was created, and then challenge that claim in court. Well, thank you. I'm sorry I ran over. Does anyone have any questions? Thank you.